And welcome to Hill and Ponton's VA Disability Blog. I'm Natalia Joffrey, the company's COO.
And I'm attorney Allison Reddick.
So today we're going to be talking about a subject near and dear to our hearts, right, Allison?
Absolutely.
Which is VA benefits for widows of disabled veterans, otherwise known as DIC claims. And before we go any further, Allison, could you please tell everyone what DIC stands for and what these claims basically are?
So DIC stands for Dependency and Indemnity Compensation, which is a mouthful and is why we call it DIC benefits. The number one question I get from veterans on a daily basis is, what happens if I pass away? Will my spouse be taken care of?
Mhm.
And it's very reassuring to them to know that there are benefits for widows and surviving dependents. So
Mhm.
what DIC is, it's a tax-free monetary benefit that is paid monthly to qualifying survivors.
Mhm.
And the way you qualify is through the veteran. It's not through the survivor, though the survivor has to qualify as well, which we'll get into. To be entitled for DIC, the veteran had to either die in active duty service, they had
Mhm.
to pass away due to a service connected disability, they had to be totally disabled for at least 10 years prior to their death, or they can get entitlement through an 1151 claim, which is like medical malpractice, proving that the VA was negligent in some way which caused their death.
Allison, so you mentioned if the veteran was disabled, so the veteran has to have been disabled for 10 years prior to their death?
Yes, so that can be either rated at 100% for at least 10 years prior to their death, or have TDIU, individual unemployability benefits, 10 years prior to their death. And that's something that doesn't have to be current. It's something that the widow can, if there was a claim for individual unemployability pending for a period of time, that can be worked as a way to get entitlement to DIC benefits as well.
Okay. And then you said due to disability. So for example, I'm on benefits for a heart condition and mid-claim or let's say I'm trying to get an increase and mid-claim I have a heart attack and pass away. Is that what you're referring to, where the widow can then come in and basically take over the claim?
Yes, so that's the easy way to do it, is
Mhm.
if they are service connected for a heart condition, that heart condition caused them to die of a myocardial infarction, a heart attack, that's listed as a primary or contributing cause of death on the death certificate. That's the easy way to get it, which are not the cases that we see. We see the more complicated ones, which we'll get into later.
Okay. And then just breaking it down a little bit more, due to VA's negligence. So we do unfortunately get a lot of cases where veterans go to certain facilities and they feel as if though they were victims of medical malpractice. And as a result of that, let's say a surgery goes awry, or they don't get the necessary wound care that they need. And then this leads to sepsis, and unfortunately, they pass away. Is that the kind of thing that you're looking for in terms of negligence from the VA?
Yes. So with the 1151 claim, it's a much higher burden and it's much harder to win these claims. However, it is possible, but it is showing that because of the negligence or carelessness or recklessness of a VA employee or technique or something of that matter within the VA's power caused the veteran's death.
Okay. And then talking about the widow or widower, because obviously it can be a male or a female that's claiming benefits. Are there any parameters that they need to meet? Like, do they have to be a certain age, or do they have to have been married to the veteran for a certain amount of time or anything like that?
Yes. So let's go into how you qualify for DIC benefits as a qualified survivor. So you have to
Mhm.
be deemed eligible as a qualified survivor to qualify for DIC benefits. And so first in line would be the surviving spouse.
Mhm.
So you have to have been married for at least a year prior to the veteran's death, as well as cohabitate with them. Though there are multiple loopholes and different reasonings for why a veteran and the spouse may not cohabit together. PTSD and domestic violence issues would be an example of that. So those are the minor requirements for it. In a lot of situations, there isn't a surviving spouse. So the next qualifying survivor would be a dependent child. And
Okay.
to be a dependent child, it can be biological, adopted, or a stepchild of the veteran. They have to be unmarried and under 18 or between the ages of 18 and 23 and show proof that they are attaining higher education, or they are what is considered a helpless child, meaning that they were permanently incapable of self support prior to their 18th birthday. And so then there's one more that could qualify if you don't have a surviving spouse or dependent children. You could have a dependent parent. And so for the qualifying spouse and dependent child, money or how much earnings you have doesn't come into play, whereas with the dependent parent it does. It's about their finances, because you have to show that you meet the income guidelines, or you are financially dependent on the veteran in order to be considered a surviving spouse. It can,
Mhm.
or sorry, a surviving parent. It can be a biological, adoptive, or even foster parents.
So I want to break this all down a little bit more just so people comprehend and give them some examples. So financial support of a parent. So if your parents are basically supporting themselves on their own, let's say retirement benefits, or they're able to work, you weren't giving them any kind of significant financial support or even documented financial support. These people aren't going to qualify even if you're unmarried and have no dependent children, right?
No.
Just the fact that you're their veteran child doesn't automatically qualify them. But if it's a situation where you're cutting them a check every month for $500 or $1,000 to help them pay for their medications, their rent, their health benefits, things like that, then that's the kind of setup, right, that you're looking for in order for them to qualify for DIC benefits as the parent.
Yes.
Okay. And then going back to helpless child, just an example I'd like to give. I'm assuming that we're referring to a child that has a well documented chronic condition that maybe isn't ever going to get better, like Down syndrome or severe autism or something in that realm. Would that be accurate?
Yes, or they were in a severe accident which caused them to be unable to support themselves. The key
Mhm.
in that is it had to have happened before 18. So those genetic issues obviously happen, they were born with them, whereas an
Yeah.
accident, something like that, that caused them to be incapacitated or unable of self-support, as long as it happened before the 18th birthday, then they could potentially qualify as a qualified survivor.
Okay. And you mentioned that for dependent children or children between the ages of 18 and 23 pursuing higher education, does that mean that they're going to qualify for benefits, but then the benefits are going to stop once they turn, let's say, 24?
Yes, so it's just for that time period.
Okay. Okay. And then the benefits would stop. All right. So, what type of evidence is helpful to support a DIC claim?
So, first of all, the death certificate would be very helpful to file. On the death certificate, it shows primary and sometimes contributory causes of death.
Hmm.
Sometimes it's easy that, like the example for the heart condition we gave before, it will be listed on there and it's cut and dry, and they can show my spouse was service connected for this heart condition. He died because of it. They get DIC benefits.
Hmm.
To be a qualifying survivor, important evidence would be if you're a surviving spouse, showing a marriage, filing a marriage certificate, dependent children, birth certificate or proof that they're in school for higher education, and for parents, their proof of their income or proof that they are dependent upon the veteran. Other types of evidence, it really depends on whether they were service connected or not, which we'll get into in a second. If they were service connected, as we explained, we just need to show that one of the contributory causes is linked to the cause of death. And in that situation, sometimes you can get the doctor who signed off on the death certificate to potentially add contributory causes. An example would be, let's say a veteran dies of a heart attack, but he had 70% PTSD for 50 years. He served in Vietnam. It was extremely debilitating to the point that it contributed to his heart condition and caused the heart attack. Sometimes
Mhm.
the doctors will add PTSD as a contributing cause, or you could get a medical opinion from a doctor to show that the PTSD was a contributing cause to the death of the veteran.
Okay. What if the veteran wasn't service connected? Can the
Yes. So
okay.
don't think that you're dead in the water if the veteran wasn't service connected.
Mhm.
The veteran doesn't have to be service connected for the qualified survivor to try to get dependent benefits or death benefits. A claim for DIC is considered a new claim. And so the survivor can submit new evidence to show that the veteran should have been service connected for the condition, and then that condition caused their death. So it's a longer route. You have to prove more.
Right.
An example of that would be, I've explained this one to you before. We had a World War II veteran that
Mhm.
he had no service connected conditions. His widow had been trying to get him service connected since his death in 2008. No one would take his case because he didn't have any service connected conditions. We took his case, found out that he served in the bowels of the ship and was exposed to a lot of noise and developed hearing loss.
Mhm.
So we were able to get his hearing loss connected because of he had conceded noise exposure because of his MOS. And then we got a doctor to show that because of his hearing loss, he couldn't hear, so he was less social. He didn't interact with people as much, and that led to the development of his dementia, which was listed as a contributing cause on his death certificate. So
Mhm.
we were able to get him service connected for something and to show that that condition contributed to his cause of death.
That was a huge win, Allison. Good job.
Yes.
But I mean, it's like we've talked about before, connecting the dots, right? And
Mhm.
that's incredible. I mean, you think now we have such respect and feel so honored when we help World War II veterans, and for most people now it's inconceivable. Everybody assumes, oh, they were in World War II. How can they not get benefits? And yet they are denied. And it's unfortunate. And luckily, by you connecting that that he did have those conditions as a result of his service, the widow, all these years later, was able to qualify for benefits. So
An-
that's
Another common example I would say that comes up a lot where people give up are non-presumptive conditions for Agent Orange. Let's say a
mhm,
veteran passes away because of colon cancer or bladder cancer, things that aren't presumptive.
mhm.
There are ways to show that even though they weren't service connected for it, getting a doctor's nexus opinion to show that the research out there is prevalent that Agent Orange does cause a lot of these cancers. And that's another way to get benefits for survivors.
So, Allison, the next question, of course, because we've talked about how you can qualify and who can qualify. Of course, people want to know how much can they receive? How much can they receive from DIC benefits? And the follow-up question that we always get is it going to be the same amount that the veteran was receiving while they were alive?
So it's not going to be the same amount. Every year, the amount changes due to cost of living. For 2020, the amount for DIC is around $1,300. $340, which would be close to the equivalent of a 70% rating if you were a veteran,
Mhm.
whereas a 100% veteran is being paid a little over $3,000. So it's not the same, but it's still a significant amount that can definitely assist the qualifying survivors with any expenses that they have.
So is that a blanket amount, like you either qualify for the benefits or you don't, and then everybody gets the same amount? Or is it, and in levels like other connected benefits where, if it's 10%, you get this much, if it's 30%, you get that much? Does
It's
everybody
just
get
the flat rate.
it is a flat rate?
Yes.
Okay, wow, all righty. So how do you apply for DIC benefits?
So the way to apply would be you file a VA Form 21534 if you are a surviving spouse or dependent child. And then because the surviving parent, dependent parent includes financial information, it's a different form. It's a 21535. And with those, you should definitely submit a copy of the death certificate.
Where can they find those forms?
You can find them online. You can also get them from the VA,
Mhm.
or we can send them to you.
VA.gov?
Yes, va.gov, and you can just Google search DIC claim form, and it'll pop
Okay,
up.
okay. How do effective dates work for DIC claims?
So there's no time limit for an application. You can file at any time, but there is an advantage of filing within a year of the veteran's death. So if
Mhm.
you file within a year of the veteran's death, then the effective date will retroactively go back to the month after the veteran's death. So let's say the veteran died in December of 2019. So
Uh-huh.
we're still within the year, and sometimes it's difficult to get service connection. It can take multiple appeals. And in 2021, December 2021, finally get service connected, then those benefits would retroactively go all the way back to the month after the veteran's death, which would be January 20 of 20. Um, so if you don't file within a year, you can still get benefits. There's no time limit, like I said, but the date where you start getting benefits would be the date of your application.
Okay, okay. What are accrued benefits? I've also heard about substitution and how do these work?
So accrued benefits, it's not, they aren't considered a death benefit because they're benefits that would have been owed to the veteran prior to his death. So let's say the veteran, like you stated before, has a heart condition. He was filing for increased rating and he passed away. If it's still within, if that appeal's still going on, then the qualified survivor can request a substitute, which just basically means they file a letter, they fill out a form and file a letter saying, the veteran passed away and I would like to substitute in to complete those claims. So they
Mhm.
were claims that were pending when the veteran passed away, and the widow or whomever steps in to request to be substituted and keep those claims alive. Then, if they win the case, the survivor is ordered retroactive benefits that were due to the veteran. So it's not a monthly benefit, it's just any benefits that were due to the veteran in those claims that they continued for the veteran.
Okay, okay, great. Any common issues you want to share that come along with these types of claims for widows?
I would think that what we see most is the veteran dying of a condition that's not service connected and
Mhm.
trying to figure out how one of the conditions listed as a primary or contributing cause, or something else that happened in service or connected to service caused their death. And that's where having a legal mind be able to fit the puzzle pieces together really helps. That's what I would think would be the most common issue.
Okay, all right, great. Well, thanks, Allison. Appreciate it.
Of course.
If you have any questions, please feel free to visit our website or call our office. Otherwise, we hope you stay happy and healthy.
Thank you.